What is just cause? And what do the 7 tests have to do with just cause? Now, stepping back a bit, let's talk about why this is so important for our work as stewards. As stewards, much of our work sometimes seems to be focused on disciplinary issues that come up for individual members. Our obligation, both moral and legal, is to represent them. Also, our obligation is to make sure that management disciplines employees fairly and objectively. Management has rules that they expect employees to follow. Management should also have certain standards that they must follow when they are issuing discipline, a way of holding employers accountable for their actions. That's where the 7 tests of just cause come in. Once management has decided to issue discipline to a member, whether a warning notice, suspension, or termination, we have a way of determining if discipline met certain standards that either validate the discipline or could potentially invalidate it. Those standards over the years were established by various rulings of arbitrators and followed for the most part by arbitrators in general. I say for the most part only because, as we know, an arbitrator, like a judge, can exercise a lot of latitude in decisions that they render, and in the case of an arbitrator, may or may not consider every one of those 7 standards of equal importance in any given case that is before him or her. But these guidelines can be very important to a steward who's defending a member who has been disciplined, either in overturning the discipline or reducing the discipline to a lesser corrective action. After all, if possible, we should attempt to resolve these types of issues without having to go to a third-party neutral, an arbitrator, because one can never predict what an arbitrator may rule. These tests or standards for just cause can be used in a Weingarten meeting to some extent, but more commonly in a grievance meeting we have regarding discipline that has already been issued. The first test, forewarning. Did management give the worker forewarning of the possibility of discipline as a result of the worker's actions? For lesser problems regarding a worker's conduct, did the employer follow progressive discipline, starting with a verbal warning so that the worker knows that future misconduct could result in more serious discipline? Often, management will place at the end of a warning notice that future issues of this nature could lead to more severe discipline up to and including discharge. These are all forewarnings, alerting an employee to the consequences of further infractions. Also, we need to keep in mind that upon being hired, a worker may sign a document that contains house rules that at some point could be used as evidence of forewarning. Let's go to the second test. Reasonable rule. If a worker is accused of violating the employer's house rules, were they reasonable rules? Were they related to the efficient operation of the employer's business or to a reasonable expectation of the worker's performance? For example, the employer expects surgical techs to be scrubbed in surgical attire and in the operating room at 7 a.m. when their shift starts. Is that reasonable? No. Some time on the clock should be given to getting prepared for work for this type of worker. This rule is not reasonable. The third test, discovery. Did management make an effort to discover whether the worker violated a rule or order before disciplining him or her? This is somewhat related to the next test, which is fair investigation, but this test focuses on whether the investigation was done in a hasty and limited way. As an example, where the employer relied on one witness to determine discipline, although there were others present when the purported action occurred and the employer failed to interview them. The fourth test, fair investigation. Was the employer's investigation conducted fairly and objectively? This could involve a lot of issues. For instance, did the employer take the word of one person over another in the investigation? Did the employer take into account that the supervisor had a disliking for the worker? Also, and most importantly, did the employer interview the worker for his or her side of the story before issuing discipline. This is a crucial point. There is no person more important to an investigation than the worker, him or herself. Fifth test, evidence of guilt. Did the employer have substantial proof of the guilt of the worker? Like some of the other tests, this test relates to whether the employer did due diligence in arriving at the decision to discipline the employee. Did the employer rely on scuttlebutt or gossip or hearsay in making a decision to discipline a worker? Did the employer simply determine based on past behaviors that the worker must be guilty? Sixth test, even-handed application. Is the employer treating all employees the same? Is he applying the same rules in the same way to all employees? Does the employer give the same discipline to one employee for a like offense that he gives to another employee? As an example, in conformance with the rules of work availability, per diem employees in a given hospital in environmental services must make themselves available 2 weekend shifts a month. And if they do not, they are disciplined. However, the per diem respiratory practitioners under the same contract with the same rules do not follow those rules and are never disciplined. There could be very many more examples. What is key in this situation is that all workers under one contract must be treated equally in all respects. And finally, the seventh test, fair punishment. Did the punishment fit the crime? For a minor offense, did the employer give a severe discipline? Should the employer have followed progressive discipline and issued a less severe disciplinary notice? In this brief synopsis of the 7 tests of just cause, our goal is simply to remember that in defending our coworkers, we hold management to these important standards. Also, there are some who might say that in defending certain workers, we are just protecting dead weight. This is not the point. We defend workers so that the employer cannot use discipline unfairly and that the employer considers carefully any disciplinary action before it is taken. Giving representation to a problematic worker guarantees fair treatment of all workers.